Welcome back, future criminologists. In this video, we will be discussing the crime of arbitrary detention. Arbitrary detention. The crime of arbitrary detention is governed by Article 124 of the Revised Penal Code. Under Article 124 of the Revised Penal Code, arbitrary detention is a crime committed by any public officer or employee who, without legal grounds, detains a person. Ito ay isang krimen ng pagdakip o pagbilanggo ng walang dahilan ng mga opisyal o empleyado ng gobyerno. From Article 124, we can now enumerate the elements of arbitrary detention, to wit: 1. Offender is a public officer or employee. 2. He detains a person. And 3. Detention is without legal grounds. Let us discuss each of the elements. First element, offender is a public officer or employee. Sino naman itong public officer or employee na pwedeng liable sa crime na ito? The public officers liable for arbitrary detention must be vested with authority to detain or order the detention of persons accused of a crime. Yung offender dapat may kapangyarihan na mag-detain. Hindi siya basta-basta public officer. Such public officers are the policemen and other agents of the law, the judges or mayors. In arbitrary detention, the offender is a public officer whose functions have something to do with the protection of life and or property and maintenance of peace and order. Therefore, a barangay chairman can be guilty of arbitrary detention. He has authority in order to maintain peace and order to cause the arrest and detention of a person. What if the public officer has no authority to detain a person? A public officer who is acting outside the scope of his official duties is no better than a private citizen. Arbitrary detention is not committed if the officer did not make use of his position or function. If the offender does not have the authority to detain a person or to make such arrests, the crime committed by him is illegal detention. So kung yung public officer ay hindi nag-a-act as a public officer, then he is considered as a private citizen. And pag private citizen, hindi po siya liable under arbitrary detention. What if the offender is a private person? What is the crime committed? If it was a private person who is the principal accused, the crime is illegal detention. Kailan naman liable si private person sa arbitrary detention? Private persons are not liable, as a rule, unless they were in conspiracy or participated as accomplices or accessories to the crime. Pag nakikontsaba sila sa public officer o accomplice or accessory siya sa crime na ang principal ay public officer. Next, let us discuss the second element. The public officer or employee detains a person. What is detention? Detention is defined as the actual confinement of a person in an enclosure or in any manner detaining and depriving him of his liberty. Ang detention ay pagkulong sa isang tao. Ang unang definition nito ay yung literal na pagkulong ng tao sa isang kulungan o kwarto. Pangalawa, pwede rin na hindi siya ikulong pero itataling mo ang kamay at paa niya para hindi siya makaalis. The prevailing jurisprudence on kidnapping and illegal detention is that the curtailment of the victim's liberty did not involve any physical restraint upon the victim's person. If the acts and actuations of the accused can produce such fear in the mind of the victim sufficient to paralyze the latter to the extent that the victim is compelled to limit his own actions and movements in accordance with the wishes of the accused, then the victim is, for all intent and purposes, detained against his will. Ang detention ay hindi lang physical. Pwede rin pagpapahayag ng takot sa biktima o mga galaw na maghuhudyat sa biktima na hindi siya pwedeng umalis. Halimbawa nito, kunyari ikaw si mayor. May inimbitahan kang taga-lugar mo sa office mo. Nung gusto na niyang umuwi, ayaw mo siyang pauwiin. Ang ginawa mo, tinawag mo yung mga bodyguards mo. This scene might make a presumption na if the victim will insist on leaving, your bodyguards will grab him and do him wrong. Ngayon, ang biktima, hindi na yan aalis because of that kind of fear. Yung biktima dito, parang nakakulong na rin siya sa lagay na ito kasi na-restrict ang freedom of movement niya. Next, period of detention. In arbitrary detention, the law does not fix any minimum period of detention. Kahit gaano katagal o kaikli yan, arbitrary detention na yon. The penalty for arbitrary detention, however, depends upon the period involved. A greater penalty is imposed if the period is longer. Sa penalty lang po material ang period of detention. Now let us discuss the third element. Detention is without legal grounds. Ano nga ba yung mga legal grounds para pwede mong i-detain ang isang tao? Kung wala tong mga grounds na to, then the detention is unlawful. First ground, commission of a crime. Pag may ginawa kang crime, as punishment, ikukulong ka. Second ground, violent insanity or other ailment requiring compulsory confinement of the patient in a hospital. Pag insane at marahas, kailangan siyang i-detain for his safety and the safety of others. Third ground, instances of valid warrantless arrest under Rule 113, Section 5 of the Revised Rules of Court. First instance of valid warrantless arrest, suspect is caught in flagrante delicto. Second instance, suspect is caught immediately after the commission of the offense when the officer has probable cause to believe, based on personal knowledge of facts and circumstances, that the person to be arrested committed it. Third instance, escaping prisoners. In flagrante delicto arrest and hot pursuit arrest were already discussed in our criminal procedure discussion. Check the link on the description box. Thank you for watching. If you like this video, don't forget to share it and to subscribe.